Okay. If anyone is able, Saul, if you are able to check that actually we are live streaming on our YouTube, I'm gonna need Cecilia. She's part of the forum, and I need her to check on just a couple of things. Oh, okay. I have a problem here. I'm gonna start admitting people, if that's okay with you. I think we all got, okay. Good morning, everyone. We are about to start in 1 minute. I'm just admitting people right now, and I'm going to give the floor to our hosts today, or co-host, International Association of Water Law. Just quickly, for those that are signing in, make sure that you follow the instructions on the screen related to interpretation, English and Spanish. Make sure you select the interpretation icon on the bottom of your screen. If you don't see it right away, click on the more and it will appear to you. And then select either English or Spanish. And then mute your original audio, please.
Rosario, can you please post that the instructions? They're not on the screen.
Okay. Hold on. Sorry about that. Thank you. Thank you, Gabriel. Okay. The instructions are on the screen. Please, please go ahead and make yourself comfortable. Grab a coffee or tea or strong coffee if you're in California or that side of the US. For those in Asia, Europe, well, maybe tea at this point. And with that, I don't want to keep waiting. I'm going to give the floor to Dr. Gabriel Eckstein to give the welcoming. Gabriel.
All right, thank you, Rosario, and thank you all for joining us today. This is a project that has been in the plannings for quite some time. This collaboration between the Permanent Forum for Binational Waters and the International Association for Water Law, looking at interconnected waters, the idea that you've got surface water and groundwater that is interconnected. We know that this is hydrologic reality, but we also know that many parts of the world either ignore it or are somehow deluded that there are no real connections, and you have challenges in management, challenges in regulatory systems, and so on. And so we're really delighted to pair up with the Permanent Forum for Binational Waters to host this first in a series of two webinars. We will have another one focusing more on the interconnected waters at the international and transboundary level, and that will happen in December. We'll give you more information about that soon. And we are also hoping to develop some kind of policy reports out of these webinars. So we are really keen on your comments and feedback as you listen to the presenters here. And we'd be interested to have your experiences. We will have time for Q&A toward the end of the session, and we will hope to receive your contributions and your experiences. As Rosario mentioned, please make sure to click on the language, the interpretation button here. because we will be speaking in both English and Spanish. And so you will want to be in the right channel so that you can hear the interpretation. I think that's all for my introduction, and I'll turn this over to Rosario now.
Thank you, Gabriel. Thank you, everyone that just joined in. We're gonna share some information of the series 2 of this coffee break that is coming up in December by the end of the event, or probably a little bit before that. I'm going to go ahead and start the introductions to the coffee break of today, which is hydrologic realities and delusions at the domestic level, regulating interconnected surface waters and groundwater. So you might see from the title that we're going to deal with very interesting, complex delusions, actually, but real. That's the only way to understand nature, is that we have to mingle our different interdisciplinary sciences and areas of expertise: policy, law, science, physics, social sciences, etc. So that's where the big question becomes: how do we mingle all those expertise and make sense out of our natural systems? And that's what the conversation is going to be focusing on today. I'm going to introduce the moderator today, but before that, I want to thank, of course, our co-host today, the International Association of Water Law, but also our sponsors that are our partners in crime: North American Development Bank, NADBank, Texas Water Resources Institute, Texas Commission of Environmental Quality, California Institute of Water Resources. Thank you, all of you, for your support to the Permanent Forum of Binational Waters and these type of events to disseminate and socialize science and policy to our border communities, and now to worldwide communities that it might be suffering from the same issues. I'm going to introduce our moderator today, as I said. Is Imad Antoine Ibrahim. He is an assistant professor in environmental law and governance at the Department of Governance and Technology for Sustainability of the University of Twente in the Netherlands. With over a decade of experience, he has worked on global environmental and legal issues across Europe, South Africa, the MENA region, Central Asia, and China. He holds a PhD in law from the Santa Ana School of Advanced Studies in Pisa, Italy. Thank you, Imad, and I'll give the floor to you so you can introduce our speakers today. Thank you.
Thank you, Rosario, for this. Before we start with our interesting discussion today, let us first introduce the 4 speakers for today. The first is Dr. Paul Stanton Kibel. He is a Water and Natural Resources Counsel at the Water and Power Law Group, PC, and a professor at Golden Gate University School of Law, where he teaches water law. He also serves as a visiting professor at UC Berkeley Hall Law School. An expert in water and natural resources law, he has published extensively, including the books Rivertown, Rethinking Urban River, and River Flow, The Right to Keep Water in Stream. He serves on the Executive Council of the International Association for Water Law, and he works as well in North Berkeley, California. Thank you for being here with us today. I go for Dr. Heping Dang, who is an assistant professor at the School of Humanities and Social Science at the Chinese University of Hong Kong, Shenzhen. She specializes in international law, human rights, and environmental conflict at the Division of Global and Area Studies at the university, and holds an LLB and LLM from Beijing Normal University and a PhD from the National University of Ireland, Galway. Her previous experience includes roles as a Senior Research Fellow at the University of Hong Kong and an EU-China Human Rights Fellow. Thank you as well for being with us today. We go for Carmen Julia Navarro, who is an Associate Professor at Chihuahua Autonomous University. She is the head of Hydraulic Sectorization Department at the Municipal Board of Water and Sanitation of the university and serves as president of the IIH Mexico National Chapter. She holds a civil engineering degree, a master's in water resources engineering, and a PhD in materials science. With extensive experience across government, academia, and consultancy, she has contributed to numerous projects and publications on sustainable water management and engineering. And the final speaker with us, Dr. Robyn Stein. She is a director of Buchler-Stein Consultant, where she works also as a consultant, specializing in water, socioeconomic, and environmental law. She has extensive experience advising governments, NGOs, and international organizations on water law, policy, and sustainable development, including significant roles in drafting South Africa's National Water Act. She holds an LM from the London School of Economics and has served in various advisory and academic positions, contributing to water law reform and policy both nationally and internationally. All right, now that we know who the speakers for today, let's start with the conversation. The title of our webinar today is Hydrological Delusion and Reality. To start with, we need to understand what is our reality. To do so, we will first understand the reality of groundwater surface water interconnection, which will be explained by Dr. Paul Stanton. And I'm now sharing the screen of the slide for that. Dr. Paul, the floor is yours.
Thank you, Imad, and thanks to everyone for helping organize today. As Imad mentioned and Gabriel did, our title is Hydrological Realities and Delusions, and I seemed like a good place to start was to give us sort of a physical, mental picture of the hydrological realities that we're often dealing with. So when we use the term interconnected waters to discuss the relationship between surface waters and groundwater, we have a bit of an image in mind, and one that I've found useful because it's where this connection gets the most problematic, is to understand how the term or the phrase interconnected waters relates to this concept of gaining streams. These are surface streams versus losing streams. So if you look at this picture, the key to understand is that if you have surface water, let's say a river or a stream, and adjacent groundwater, what's really critical is the elevation. So if you have a situation where it's, let's say a relatively flat terrain, where you have a surface water and then you have groundwater whose elevation is lower, that is what we would generally call a losing stream. So the surface water, the stream, is provided that it's not encased in concrete, but we're not going to talk about that yet, is losing water to the groundwater. So you have that type of interconnection. The one that tends to be more problematic is what is called a gaining stream. And a gaining stream often happens on steep sloped terrain, where portions of the groundwater, surrounding groundwater, often in the hillsides, are actually at elevations that are higher than the surface water. So the groundwater is actually is tributary to the surface water. And the problematic aspect is that when you pump that groundwater, you can take what was a gaining stream, right, that was gathering water, collecting water from the groundwater around it, and turn it into a losing stream, because the groundwater table goes down such that the elevation of the groundwater is below and it becomes a losing stream. And this can have serious impacts on in-stream flow. So for my mind, when we're thinking about the relationship between interconnected waters, understanding this concept of gaining streams and losing streams is very helpful. And that's kind of the hydrologic reality piece. What I think we're going to turn to now, Imad, is the hydrologic delusion piece. And in the United States, where I'm from, we don't really have federal or national groundwater law, or we have water quality law, but not really relating to water usage. at all. So we're dealing with this at the state level. And in California, and then I'll get into this more later, we have separate rules and regimes for surface water and for groundwater. We treat them as if they are separate things. And we actually have different entities. We have a state entity that can regulate surface water, but it can't generally regulate groundwater. And that's where the hydrologic delusion comes in, that we have a hydrologic reality that they often are interconnected. And particularly the pumping of groundwater can reduce in-stream flow, but we have a legal and policy regime that continues to ignore this hydrological reality and continues under the delusion that they're separate. So I just wanted to put that image out there, and maybe it's something as we get into the discussions about interconnected waters, the use of those terms or phrases, gaining stream and losing stream, might be helpful. Thank you.
Thank you, Paul, for this. So we just seen the reality of, we understand science, we understand what's happening on the ground. Why are lawyers unable to understand that? Do lawyers need some sort of psychiatric help to understand data and groundwater and geology and the connection between surface water and groundwater? If you have all the experts in the world who are telling lawyers, listen, we have these interconnection, please regulate it. What are the problems? Why aren't we able to grasp that with that as lawyers? And I'm asking this for Paul and Heping, considering their experience in the US and China. So Paul, you can also start as well concerning this question.
Seems like you're attacking the lawyers, Imad, but I won't take it personally. It's a great question, and I don't think there's a very satisfactory answer other than the one that I would turn to, at least for the experience in California, is sort of historical inertia. I think there was a time, let's go back to the late 1800s, early 1900s, when we developed some of our rules and institutions for managing water, both surface water and groundwater, when we didn't really understand this interaction very well to the extent we do today. And I think the sense was we didn't really have a good means of being able to map out the interconnection in a intelligent way. So we came up with a rather crude system of saying, well, we know that we can see surface water and we know there's some water under the ground, so let's just treat them differently. The second part of the answer, and it's also pretty unsatisfactory, but is that the early groundwater law was essentially the rule of no law in California. It was the rule of capture, which meant we're just not going to regulate groundwater because we don't know what it is, where it is, or how to do it. And we're just going to focus on creating a more well-developed rights system for surface water. So it's been a transition in California over the last 100 years. I don't think we're as far along as we need to be to just not regulate groundwater. And that's not working very well because many of our basins are in overdraft. And people have gotten used to not being regulated at all. And so the shift towards regulating groundwater in general, and then in particular regulating interconnected waters, which focuses on the connection between surface water and groundwater, there's been a lot of resistance to it. I think other states in the southwest of the US, like Arizona and New Mexico, Gabriel, you might be able to speak to Texas, have made a little more progress than California. We are often put out there as the poster child for how not to regulate groundwater. If you want to learn how to not regulate groundwater, come to California and we can teach you how not to regulate it. So that might not be a very optimistic answer, but that's my take on it.
Let's see, maybe there is a different developments in China based on which also lawyers are not able to regulate groundwater. Heping, what's the situation in China?
Thank you, Imad. The story of China will be, I don't think lawyers cannot understand groundwater, but the main picture will be lawyers are not given the place to regulate or to manage groundwater. The management system was mainly dominated by experts from other disciplines, for instance, engineers or ecologists from natural science. So that's my main observation for this question.
based on this observation, next question would be, well, should lawyers possess sort of interdisciplinary expertise, especially specializing in water resources? So law and geology, law and something else, so that in a way to be able to assess this interconnection. I was wondering about that, and would be happy to ask Carmen first. What do you think? What do you think of that? And based on her Mexican experience.
Sí, la realidad es que es complicado que los abogados tengan un conocimiento mayor sobre el tema de hidrología, de hidrogeología. Sin embargo, es conveniente que ellos tengan un equipo que les muestre o les explique las condiciones del ciclo, de la conexión del ciclo hidrológico, ¿no? De la fase superficial y subterránea. Y además, creo que si bien el abogado como experto en leyes puede entender de forma básica estas interrelaciones, creo que debe de asirse de personas que tengan esta expertise y le ayuden y le apoyen para entender esta interacción.
Thank you for that. Robyn, does the South African experience ring any different bells than the Mexican one?
I think it does in many, many respects. And when I heard your question, I thought to myself, why not? Why should lawyers not acquire some measure of technical expertise, or as they would do in the ordinary case of litigation where technical issues are abound, they're required to make themselves familiar with such technical expertise. But from the vantage of the South African legal framework for water resources management, given that the opening premise is that water, wherever it occurs in the hydrological cycle, is a resource common to all, the National Water Act, on that premise, specifically governs or regulates integrated water resource management or management of the resource, bearing in mind that surface and groundwater are inseparable. The hydrological cycle is not split, divided at any point within the regulatory framework. So, yes, I do believe that an integrated approach, particularly when it comes to determining policy, determining strategies for integrated water resource management, mechanisms should be used for lawyers to integrate with technical counterparts such as scientists and engineers. I think this is key critical for effective implementation. We've certainly in South Africa seen examples where there has been a clash between disciplines. What loses out, and that is the resource. The resource and its healthy and sustainable management is the loser. So that is a very long answer to what should be a very short answer to the question. Yes, why not?
But given that, and looking at the shortcomings of having lawyers involved in the groundwater debate, wouldn't make sense if we leave it for other experts? I mean, we have the Chinese experience where we have non-lawyers drafting groundwater and surface water laws, and then you have US experience where lawyers are mostly there doing the work. So if we try to compare both, we would like to see what would happen then. So I'm more curious about first the Chinese experience. What are the main considerations or observations that one could notice when non-lawyers are drafting water laws?
I don't think there are any particular concerns, but I think the main mentality behind the current management system will be they will consider this mainly a job of engineers or people from natural science. So I think what we need to do for the further step will be include legal perspective into the current management system. For instance, even the water extract permit in China is just understood as someone has the qualification to use the machine to take water out. They don't understand from the legal perspective as this is a property right or what kind of the right one person can possess with the water you get. So my suggestion, or for me, the Chinese way out will be adding the legal story, legal management into the current management system. But so far, I think the decision makers, I just think this management doesn't really concern you. You are not very important in the management system.
Thank you. Paul, it seems that the legal story is mostly in the US more than in China. Is that correct? And is that the way to go, or we need a combination of stories? You're muted.
There we go. As to whether it's specific to the United States, I certainly know in the southwest of the United States, we have this ongoing problem of what I would call hydrologic delusion. But I guess to respond to your question, I'm not sure how useful it is to think about it, whether the lawyers or the scientists should be in charge. The way I look at it is the law is simply the set of rules and institutions that govern how we use groundwater. That's the law. That's what the law does. As to who participates in that governance structure and who participates in setting those rules, lawyers might participate as they participate in all efforts to sort of have governance structures and rules, whatever the topic is. So I don't know if it's necessarily lawyers versus scientists, as it is versus whether collectively there are different government systems that decide to govern based more on hydrologic realities, which is messier and more confusing than to have a more simplistic version that's based on hydrologic delusion that seems more straightforward, but is scientifically not really adequate. And I don't think it's a question of the lawyers versus the scientists. And I guess the other thing I would just add in defense of lawyers is that any set of laws and institutions that govern, that lawyers often play a role in, is outside their legal expertise, right? Laws cover a tremendous number of topics. So the thing that lawyers should stick to the legal things and not get involved is not really practical, because almost every act of governance involves some area of, whether it's public health, involves areas of expertise that are, outside the core of lawyers.
Thank you, Paul. Given that we established that actually we need both lawyers and scientists to address the problem, the next question is, where do we go from here? How do we tackle this delusion? One way to do so is to start by focusing small on the challenges and opportunities seen when it comes to interconnected water regulations at the domestic level. Hence, one would wonder, for instance, what are specific challenges one could see when the state is trying to regulate interconnected surface water and groundwater? And for that, I first asked Carmen, what are specific challenges noticed in Mexico when attempting to regulate the interconnection or the relation between groundwater and surface water?
Bien, el problema en México es que no existe datos o información que pueda ser convencida para tanto la parte gubernamental como para los usuarios. Entonces, al no tener confianza con los datos que se establece una regulación, pocas veces es exitosa, ¿no? Entonces, la realidad es que la falta de datos y la confianza en ellos es un reto, un desafío importante para la regulación de las aguas, tanto superficiales como subterráneas. En México, desgraciadamente, la ley de aguas nacionales dice que las únicas personas o la única institución que puede tener estos datos o generar estos datos y con ellos se regule es la Comisión Nacional del Agua, lo cual evita utilizar la información de otros actores. Entonces, esto hace que no haya una confianza porque la institución gubernamental tiene ahorita poco espacio y pocas oportunidades para generar datos y no tiene inversión para ello. Es difícil estar supervisando miles de pozos o miles de usuarios y esto hace que exista un rezago en esta situación de cuantificación de los datos. Entonces, siempre se da de forma reiterada algunos elementos para regularizar las situaciones administrativas y legales de los usuarios, pero siempre están atrás. Es decir, si yo hago ahorita una disponibilidad y la publico como gobierno federal, resulta que hay en cartera mucha información que no se está tomando en cuenta. Entonces, queda como una película que no es del día de hoy, no es presente, es de hace 5, 10, 15 años. De hecho, las publicaciones que hace de forma presente, actualizada, el gobierno federal, tiene información de hace 15 años. Entonces, ahí es un reto importante. Cómo generar datos para compartir y poder realmente sentarnos a regularizar esta reglamentación.
Thank you, Carmen. Robyn, are the challenges in South Africa different? You are muted.
There you go. The challenges, can you hear me?
Yes.
Thank you. The challenges in South Africa are not much different, but okay, on the one hand, there is a very comprehensive data management and collection system. And the National Water Act itself does oblige government, whether it be the minister or the Department of Water and Sanitation, to make that information available to the public. So that is on the data and information sharing aspect. But when one actually starts looking at the data qualitatively, there are oftentimes fairly large debates as to what value that information actually has when it comes to operationalizing, for example, the grant of large licenses. So why does this happen? Well, it's always a resource problem: funding, human resources, the availability of technical experts, sometimes on an emergency basis. So, yeah, I think that is what characterizes the South African position, which is not a major juxtaposition in any way.
Well, in the face of the challenges seen in Mexico and South Africa, I am guessing there are also opportunities noticed elsewhere based on the developments of regulations as well. And I'm wondering about that. So first, I was wondering whether there are opportunities noticed in China when it comes to groundwater, surface water regulations.
Thank you, Imad. The opportunities in China will be, currently in China, we have massive management measures towards surface water. So we have seen the trend of using the same management system, trying to expand it to manage groundwater. We see the trend. So this is, for me, is the opportunity. So we are looking for instance, the central government even have quota for each of the provinces, how much water you can take each year from surface water. So we are looking for the same measures like central government or different level of government can put a quota into groundwater. So same measures, we have seen a trend to be implemented in groundwater. But some of the key indicators we will be interested to see whether they will be used in groundwater management.
Thank you for that. Paul, I go back to the US. Are there different opportunities there?
Here's my hand.
You are muted.
I think the answer is yes. And the one that I would point to as I think a very positive development was in 2014, we passed a law in California called the Sustainable Groundwater Management Act. And without getting too far into the weeds, it requires the designation of a groundwater sustainability agency for each groundwater basin in the state. And there's about 130. And it requires the preparation of a groundwater sustainability plan for each of those basins. What's interesting about the Sustainable Groundwater Management Act, which we sometimes call SGMA for short, is that as one of its undesirable results to be avoided through these plans is where there are significant adverse effects on beneficial uses of interconnected surface waters. So we see a law actually dealing with hydrological reality saying there are interconnected waters that can affect beneficial uses of surface waters, and the plan needs to address it. But importantly, and this speaks to the point that Carmen Navarro made about the lack of good information and data, is the law requires that each groundwater sustainability plan include detailed hydrological models showing the inflow and outflow of water into the groundwater basin. And obviously that's an opportunity that to do that type of modeling, you need good information and data about this interconnection. And it also requires the development of something called a water budget, which is an interesting term because it's usually used in economics or business. But the idea is that with an aquifer, we kind of like income, right? We have water coming in to the aquifer. That's kind of a losing stream. If you think back to the image I showed you at the beginning, a losing stream is contributing water to the aquifer. And then we have water going out of the aquifer, right? Kind of like payments for budget purposes. And that's really a gaining stream where the aquifer is losing water to the surface stream. So I think the fact that SGMA in California recognizes the connection and the need to address it, and then creates the obligation to actually create models and create budgets and data and information, so to express that is a significant step forward. And I think in part because it addresses what Carmen talked about, is that there's often just an information data gap. So steps that you can take to help address that information data gap are an important starting point.
Imad,
Yes.
I think I'd be remiss in not picking up something significant that is interned in the National Water Act, a document or documents as we develop through the years. But the National Water Act, similarly to SGMA, does enjoin the minister, and through the minister then it becomes a power, function and duty of the department to establish what is called a national water resource policy document. Two versions of these policy documents have been developed to date. Essentially, data collection and management is dealt with in the policy document. It informs decision-making from a technical perspective for water use licensing, reallocation being one of the founding principles of the Act. And it details water quality, management strategies, and the like. Without going on for hours on the document, I just want to emphasize what is unique about it, and that is this document, which is replete with technical information and is informed by engineers, scientists, hydrologists, and the like, eventually acquires the force of law, and thereby the details of which must be taken into account by the minister or the national department when exercising any power, function, or duty under the Act. The same goes for catchment management agencies, which are established under the Act at the regional level within a defined hydrological catchment. Those agencies are also required to develop their catchment management strategies, which become equally enforceable once they have been approved by the minister after a public participation process. I just think that these are unique features whereby a policy document, technical issues, acquire the force of law and must be taken into account in the implementation of the wider water governance framework under the legislation.
Thank you, Robyn, for that. That was very insightful. And I'm going to follow up on that as well. We have the problem of groundwater, surface water. I hope we all agree that there is a human right to groundwater and a human right to surface water. I hope there is consensus of that. Could this be a point of a starting point to understand the connection? Could the human right to water help in pushing all the actors to actually take into account this interplay between surface water and groundwater? I'm asking first, Heping, this question. You're muted.
Sorry. To begin with, human rights to water is not recognized in Chinese law so far. So what I can tell is from the current policy, domestic use of water or groundwater or water for agricultural use has been prioritized than any other uses. So that's the only thing we can tell from the current policy in China.
Thank you for that. How about South Africa, Robyn?
In South Africa, the human right to water is governed from a constitutional perspective and from a legislative perspective. Under Section 27 of our Constitution, access to water is guaranteed as a fundamental human right. It's not an absolute right. It is subject to a double limitation in the Constitution, in that the state is obliged to take reasonable legislative and other measures to achieve the enforcement or application of this right. So where resources are not available, the state cannot be held to ransom, so to speak. Essentially, the National Water Act itself gives legislative effect to that constitutional right and prioritizes the right to water for basic human needs as one of the key founding principles of the Act. Through the mechanism of the reserve, we once again see the prioritization of access to water for human needs, in that the reserve is the first user of water and cannot be allocated outside there's always an amount that is held back in a resource, including a groundwater resource, that cannot be allocated elsewhere. It must be retained to ensure equitable access for human needs and obviously aquatic protection, the protection of aquatic ecosystems. So the National Water Act does give effect to the constitutional right enshrined in our Bill of Rights. It is operationalized on the domestic level through a sister act, which is the Water Services Act, which deals with the supply side and reticulation. The National Water Act is limited to freshwater resources, unified in the hydrological cycle, surface and groundwater.
Thank you, Robyn, for that. Besides the human right to water, there are many factors that play a role in water, surface, or groundwater management. Some of them can be religion, culture, customs, or other factors. And I'm going to ask this to Paul and Carmen. Do you think any of these factors or other factors actually play a role in creating this delusion? Or actually, they're on the opposite, they try to solve it? So, Paul, what do you think of this?
I do think they can play a role in responding to the delusion and developing better structures. But I think I would make a point that actually relates to your last question about the right to water, the human right to water, and vital human needs. In California, at least, one of the limitations to the concept of the right to water right now is that it really focuses on consumptive uses of water. Diverting water out of stream for drinking water, for sanitation, maybe potentially for irrigation, but they're all uses of water. They're all out of stream consumptive uses of water. In California, some of the flashpoints around interconnected waters have actually dealt with non-consumptive in-stream uses of water. And in particular, if you look at the picture that I showed at the beginning of a losing stream, right? We've had a number of streams in Northern California, particularly in the Klamath River Basin, where excessive groundwater pumping has caused the surface water to vanish in the summer, not just to be depleted, to disappear. And this was particularly true of a river called the Scott River, which is tributary to the Klamath. The main concern there was not water users, whether it's for vital human needs or other needs. The concern was that there were endangered fisheries, salmon and steelhead trout, that were using the Scott River, and that when the groundwater pumping caused the surface water to disappear, it had significant adverse impacts on in-stream fisheries. So I guess, in terms of, you asked about cultural issues, Imad, and to point out that it's not simply about water rights and water users and consumptive uses of water, that given that we use the term beneficial uses in California, there are beneficial in-stream uses of water that can be impacted by groundwater pumping when they turn a gaining stream into a losing stream that the law is trying to capture. And most recently, I can talk about this maybe a little bit later. I know we're trying to keep the responses short. We had an important decision, California Court of Appeals, related to the Scott River and fisheries issues, which held that something called the public trust doctrine applies to groundwater pumping when we have interconnected waters affecting surface waters. And that's an example of how the law is adapting to deal with these non-consumptive in-stream uses, at least here in California.
Thank you for that. Carmen, what's the situation in Mexico?
Bueno, creo que coincido con Paul en lo que dice de esta situación que se da tanto en Estados Unidos como en otros países. Creo que es algo muy común que la educación o la cultura de los usuarios o de la población en general incide en la forma en que usemos el agua y la importancia que le damos. Muchas veces el usuario se hace a un lado en la responsabilidad del manejo y gestión del agua, ¿sí? Se lo deja en manos del gobierno, nada más. Y cuando la comunidad como usuarios busca intervenir, entonces hay un choque de entendimiento de la situación. Entonces creo yo que en este sentido, en México en particular, sí tiene que ver con la cultura, no solo de las personas que están en el gobierno, ¿sí? Sino también de los usuarios en general. ¿Qué pasa ahorita la problemática que tenemos en México? Tenemos N acuíferos sobreexplotados, pero este no es un problema que tiene 6 años, es un problema que venimos arrastrando de hace 30 años, o sea, de cómo se llevó a cabo ese seguimiento y ese monitoreo de esa gestión, que no estuvimos actualizando y gestionando esta situación de cómo utilizar otros factores y elementos para la regulación. Como les decía en mi anterior intervención, recurrentemente la Comisión Nacional del Agua hacía regulaciones para que los usuarios se adherieran a la cuestión administrativa legal, ¿no? Y no había respuesta. Tan es así que tenemos N pozos que no tienen un sustento legal. Pero si vemos ya, tienen un sustento, como dicen los abogados. De hecho, utilizan el agua y tienen años utilizándolo. Incluso tienen infraestructura utilizada ahí que han invertido. Entonces, viene una cuestión social de si no tienen derecho legal para utilizar el agua, pero ya tienen infraestructura y el gobierno les quiere quitar, obviamente, esa infraestructura, todo eso es un costo económico, social y político. Entonces, creo que sí tiene que ver la cuestión cultural y educacional de ambas partes, ¿no? De tanto gubernamental, que debemos cambiar la forma de ver las cosas y entender cómo el usuario vive y percibe, ¿sí? Y el usuario debe entender que no es nada más responsabilidad de gobierno, sino que también es responsabilidad de nosotros como usuarios entender la problemática porque somos parte de ella y somos parte de la solución.
Thank you, Carmen, for this. Obviously, we can ask 1 million questions about this topic, ranging from the role of different legal systems, civil law, common law, mixed regimes at the country level, or even how do administrative levels, in terms of local provinces or even national, play a role in further complicating this divide. But given the time limit we have, I have 2 final questions for the participant and or the speakers. I'm going to ask each speaker to take a minute and think of one small provision that they would like to include in a futuristic, domestic, interconnected groundwater surface water regulation that could set or pave the way towards dealing or solving this delusion. And I would start with Paul for this. Paul, what would be your ideal provision to be included in this futuristic, idealistic sort of regulation?
I think your question is in our jurisdiction, right? Rather than globally.
Yes.
I think a significant step in California would be to provide our state water board with authority to regulate interconnected groundwater. Right now, they have no authority to regulate groundwater. So the only way we resolve these disputes is through these enormous, protracted, dysfunctional lawsuits, which is a terrible way. That's the only dispute resolution mechanism available. So there actually have been proposals. One was made about 15 years ago, actually by a very famous law professor, Joseph Sachs, who suggested that that was actually the intent when they created the state water board, that it would have jurisdiction over these interconnected waters that affected surface water rights. His reasoning was that we can't actually coherently regulate surface water rights if you don't give us this authority because they're interconnected. But the problem was that, notwithstanding that suggestion, these recommendations, there are people in the groundwater community who feel at the end of the day, this is going to result in greater restrictions on their ability to pump groundwater. So they've opposed it. But I think having a more integrated governance structure here in California that provided the State Water Board with that authority would be a significant step forward, but it hasn't happened yet.
Thank you, Paul, for this. Heping, what would be the ideal Chinese provision in this regard?
I have a small question. Is it one provision enough to solve the problem? Okay, so
Absolutely not. Absolutely not.
Okay, so I think groundwater in general, that the management in general, that will be make legal principles, philosophies involved in the management. But on the illusion of interconnections between surface water and groundwater, I think just make it simple, like they are interconnected or they are the same, they are part of water. But I'm not sure which country have this kind of provision. Thank you.
Fair enough. Carmen, do we have any developments in Mexico in this regard?
Bueno, ahorita hay varias propuestas de modificación a las leyes de aguas en donde se involucra el agua subterránea, ¿no? Hay propuestas que se están decidiendo ahorita en las cuestiones legales, pero creo que estas propuestas, para mí, le hace falta una cuestión más social, más técnica también. ¿Por qué? Porque es una cuestión más legal y administrativa, ¿no? El enfoque que se tiene ahorita en las leyes de México es que las normas son analizadas por comités específicos y a veces no hay una armonización entre normas que se refieren a una situación en específico del agua, ¿no? Entonces, esa no armonización por la falta de integración de enfoques hace que sea complejo ahora sí, la efectividad de estas regulaciones que tenemos. Y creo que ahorita en México hay una gran oportunidad con estas nuevas propuestas de reglamentación para incluir aspectos sociales, políticos, que tienen que ver con esto que hablábamos en el segmento pasado, ¿no? De la interculturalidad. ¿Por qué? Porque eso incide de que sea efectivo una cuestión de sanción o una cuestión que tenga que ver de procesos administrativos cuando la gente lo hace suyo, hace parte de ello. Yo creo que ahorita es una gran oportunidad para México empezar a analizar estas propuestas e incluir cuestiones sociales, filosóficas, como hizo Heping. O sea, creo que tenemos una gran oportunidad.
Robyn, that's the South African. Can South Africa offer a different suggestion or a new solution within a provision?
It's a very hard question to answer in the sense that under the South African legal framework, groundwater and surface water are regulated interconnectedly. There's no separation or there's no delusion when it comes to regulation. What I do think, however, is that the legal framework does require tightening up on the implementation of some of the fundamental principles of the Act, flowing from the public trust doctrine that is stipulated or established under Section 3 of the National Water Act. The minister, as custodian, is required to ensure sustainable use that is aligned with equitable socioeconomic and environmental priorities, but implementation does remain a major challenge at the end of the day. And what I would like to see in future regulations or future amendments to the Act is a much greater attention to specific areas around groundwater governance in and of itself being given a voice in the Act and not embedded in policy and strategy documents. I think that is important without separating or introducing a delusion into the National Water Act itself. Do you understand where I'm going with this?
Yes.
The other aspect, which in South Africa, on the ground and as an objective fact, is the need to give a voice to climate change, which has a very, very important impact on groundwater management in the country. The climate variability that we tend to experience takes us into drought cycles. And as opposed to, again, strategizing and managing this particular aspect, which has a fundamental impact on groundwater, when drought is experienced, for example, yeah, given all of that, I think that climate change certainly does need a voice, given the impact that it does have on groundwater and the reliance on groundwater for not only livelihoods, economic purposes, but also obviously for basic human needs outside of the service and supply side. And on that front, municipalities do rely on groundwater abstraction to provide services. So it's multidimensional, it's a major challenge, but it's about now prioritizing to meet the needs of the future as the legislation adapts and grows with variability.
Thank you, Robyn. Last question for everybody. We discussed that we have a hydrological, geological, legal reality that we all acknowledge. And it seems there's a consensus over the fact that we are having a collective delusion / amnesia of this reality, which is problematic if we want to ensure the good governance of groundwater and surface water that are interconnected. Where do we go from here? Are we bound to discuss this topic forever? Because as lawyers, we will never find a solution besides discussing this topic, or there is light at the end of the tunnel. So what's the future? What the future holds for us? And I start with this with Paul. Paul, are we bound to discuss this forever, like all of these all these questions that we never find a response for? Or there is a light at the end?
I like to think that there's a light and that it's not an oncoming train. Imad, that's the caveat that we always use with the light at the end of the tunnel, because if it's an oncoming train, that's not good. The reason why I'm somewhat optimistic about the trajectory here based on the experience in California is it actually has to do with self-interest, in that whether you're focused on using surface water or whether you're focused on the beneficial uses of keeping surface waters in stream for fisheries, the people that are concerned either with maintaining those uses, those rights to use surface water, or maintaining the flows to support fisheries, they can't achieve those goals. Those interests are threatened by the failure to have proper governance and regimes in place, governance regimes, the law, for lack of a better word, to regulate these interconnected waters. So getting back maybe to your initial sort of framework, Imad, rather than viewing this just as the scientists versus the lawyers, and the lawyers wear a jersey that says "Go Delusion," and the scientists wear a jersey that says "Go Reality," and then they fight it out. I think there are stakeholders out there Some maybe representing NGOs, representing fishermen, representing tribes here with fisheries, representing people reliant on surface water uses that will see it in their own interest to improve this link and to move from delusion to reality, because it serves the objectives that they're trying to achieve. And those people aren't really wearing the scientific jersey or the legal jersey. They're wearing whatever their interests are. But I think increasingly there's a recognition that there are a lot of interests that will be served by improving this. So I see steps being taken a little bit haphazard, not as coherent, not as fast as I would like, to address it, and I expect that to continue.
Thank you, Paul. Heping, do you share Paul's optimistic observations from China?
Yes, I do. In China, the governance measures are very reactive instead of proactive. So what happened is people are more aware of the problem of groundwater. We'll gradually learn, have more knowledge regarding the fact that groundwater and surface water are interconnected. So I'm sorry to say that, but in China, in different provinces, why people begin to be aware that we have a groundwater problem is because they see accidents, they see problems. So we will also see when they find out we have accident, for instance, some cities, they are trying to build a subway, then have an incident. Then what's the reason? They find out because we overused our groundwater. Then this province or this city will have a harder measures in managing groundwater. So when we see more of the problem, because the policy are very reactive, so we'll make more places, we'll begin to wear the nature of groundwater, want to have a better governance of groundwater. So we already see in China between different provinces, when they have aware that groundwater is a problem, then the governance measures will be better. So we see the difference between different provinces. So that would be like a chance to progress, because you see the consequence already.
Thank you, Heping. Carmen, is Mexico jumping on the optimism train, or do we have to pull the brakes?
No, yo creo que me sumo al optimismo de Paul y de Heping. La verdad es que creo que ahorita hay un cambio de generación que está viendo que esta desarticulación y fragmentación en el abordaje del agua superficial por un lado y el agua subterránea por otro lado no ha sido exitoso. Y tan no ha sido exitoso que la sostenibilidad de los usos, como dijo Paul, no está garantizado para el beneficio colectivo, económico, social y político, ¿no? Entonces, esto va generando cada vez mayores conflictos. Entonces, yo soy optimista en el sentido de que debemos sentarnos, o nos sentaremos, los actores de los diferentes usos y ahora sí, parte gubernamental, usuarios, en general, población, para poder mejorar el entendimiento y el abordaje de esta interconexión del agua superficial y agua subterránea. Entonces creo que me sumo al optimismo y creo que México empezará a generar otra forma de regular sus aguas.
Thank you, Carmen. Finally, Robyn, has optimism reached the South African shores? You're muted.
Sorry, I beg your pardon. I think, yeah, in 1998, when the National Water Act was enacted, the delusion was dealt with quite effectively. And, you know, by repealing and replacing the previous act, which did in fact entrench the delusion and separate it off, management of and regulation of groundwater and surface water, as I've, said over and over, the National Water Act does not. But I'm always interested in implementation, effective implementation. And another very positive aspect of the National Water Act is that it does develop and is very committed to a system of integrated water management, but of the South African variety. Integrated water resource management is, in this country, integrated water development management. And that is because the legislation does underscore the need to align socioeconomic, environmental priorities with equitable aspects and obviously sustainable use of the resource. So when it comes to implementation, I do think that we can avoid tripping back into a delusional state by resourcing up and sharpening the regulatory framework to ensure effective implementation and achievement of the underlying provisions of the National Water Act, and that is beneficial use of the resource, surface or groundwater, in the public interest.
Thank you, Robyn. On these very positive notes, I invite Dr. Gabriel Eckstein to join because now we're going to move into the period of questions from the audience. But before doing so, I'm a little bit curious about Gabriel's opinion here. Gabriel, what do you make of the conversation that took place so far? And are you on team optimists or not?
Look, I find the whole conversation, stimulating and interesting, personally, because I've been so invested in this field for so many years. So just to have people who share that kind of interest and bring in perspectives and ideas, I think is exciting. Am I optimistic? I think I have to be optimistic. Otherwise, I wouldn't be able to do this every day. I think we are making small forward steps, in the different countries. And you see legislative changes. In fact, there are countries who did not have any groundwater legislation that now have something, so it's already a small step. They may not have a great or a good groundwater legislation. Not a country, but a state, California, didn't have a statewide governance system for groundwater until Sigma came around. And I'm not sure that Sigma is the best answer. I think Paul might agree with me. But at least it's a start. So I think there's forward movement, which makes me, so positive about it. But so should we move to the questions?
Yes.
Yeah. So we've received a number of questions, and I urge you all in the audience, if you have more questions, to please pose them here in the chat. But I want to jump to one that was presented, a comment that was presented by Andy Archer, and he makes the point that in addition to scientists and lawyers, there's actually a third species of participant, and that's the legislators. And they may not be scientists or lawyers, or they may be one or the other, but they have a completely different approach and perspective to the creation of laws from a political perspective. And so Andy makes the comment that, shouldn't we be educating these legislators on the legal issues and on the scientific issues? But I also want to ask, what about the politicization of water? Because very often we use water sort of, in our negotiations for things that have nothing to do with water. So I don't know if any of our panelists from the different countries have any experience with either education of legislatures or dealing with the politics of water.
I'll offer preliminary thought. In the United States and even in parts of California, I think there is a political view that views basically that the government, when it gets involved in anything, tends to do more damage than benefit. I don't subscribe to this, but I think there are constituencies that start with that premise. So the idea that the government gets involved in anything is generally a bad idea and is going to lead to bad outcomes. So when you start with that kind of a political viewpoint, and one against, I'm not endorsing it, I'm just saying it's out there, and that there are politicians and legislators that are responsive to that and maybe even agree with that, they're going to be resistant to anything. So they don't want more involvement of the government in anything, be it groundwater or be it anything else. And it can be very difficult to, it can be a challenge to engage people with that political mindset in about why there could be additional positive role for the government being involved in governance rather than sort of the delusional chaos that we have right now. I think there's a political cultural mindset that is just not receptive to the idea of government involvement in parts of my country. I would say statistically, based on last week, it's about 52% versus 48%, to break it down for you. That's a joke, by the way. That's a political joke.
Anyone else? Robyn, please. You can unmute, please. Robyn, if you can unmute.
Beg your pardon again. Just a very short input. Coming from a country where we had to move into democracy and deal with the legacy of apartheid, there was obviously a political aspect to the water law reform process. But at the time, as it is this time, the government was ruled by the ANC, the majority party, and the process was exceptionally engaging with the legislators, to the credit of the late Kader Asmal, who I worked for at the time. There was enormous benefit in spending time with the portfolio committees, doing presentations, bringing in experts. It created a highly participatory approach as far as the lawmakers or legislators were concerned, and that goes to the provincial level and obviously to the national level. The political threads ran throughout the economic sectors, and there again, there was an enormous amount of consultation. And we were able to go back to the lawmakers and, present the outcome of those engagements. So I do agree that education of the legislators is of vital importance. Certainly in terms of our constitutional democracy, it is essential that they understand the content and impact of the legislation or the bill that is put before them before it can possibly be enacted and given the force of law.
Thank you, Robyn. Heping or Carmen, would you like to add anything?
Yeah, in China's case, usually in every discipline, if you want to educate legislator, you organize a conference with them, politely lecture them. If they think your topic is useful, they may organize a training and invite you. So this is the main way to educate legislator in China. In terms of like the politicalized of water management, I think it's always the case. For instance, in China, the shared water resources between different provinces, then how to divide water, how to allocate water resources. Groundwater and surface water is an issue. And in China, we also have transboundary water between mainland China and Hong Kong. This is always political. So this always even within China, there are negotiations between different provinces. So not just the water management involved, political factors and other things are also involved in water management.
Carmen, did you have anything you want to add?
Yo creo que la mejor forma de apoyar y educar, como dijiste, de los legisladores, es involucrarnos con ellos. Nosotros, los profesionales, los de cualquier ramo, llámese abogados o técnicos, involucrarnos con los legisladores para que ellos puedan percibir y entender la problemática y poder proponer algo más aterrizado y que pueda ser eficaz.
All right, thank you all. I'd like to move on to another question. Itzhak Alster made a comment here that I want to kind of pose to all of you. He says he would argue that the regulation of interconnectivity is easier where all of the waters are state or publicly owned than when they are private rights. And I want to just add a nuance here that you have the idea of ownership of the water resource, which I think many countries and most of the US states do have that approach. I live in Texas. That's not the case here. We have private ownership of groundwater, but there's actually a different nuance in US law, which is if the state might own the water resource, but you do have a private right, a usufructuary right, which is a property right, a right to use, which becomes a property right. And I think what Itzhak is suggesting is that if you don't create property rights in water or even the right to use, just have licenses that are revocable by the government, that might make it easier to regulate interconnected waters. And I wonder if what the situation is in the countries of our panelists here. Robyn, do you want to start?
Oh, absolutely. If I may, Gabriel, as you know, in South Africa, water is considered to be a common good, a resource that is common to all and is incapable of private ownership. Even the right to use water does not in any way create a property right. It is called an entitlement, that is the language of the act itself, and no property right arises from a license or which grants obviously a right to use. And this change is absolutely significant. It's a 360 shift from the previous legislation, which recognized that a distinction between private rights and common rights. So we've opted in South Africa under the National Water Act for this public system in order to ensure that we are able to address issues of equity of access, sustainability, and then obviously balancing those aspects to national socio-economic and environmental priorities. In effect, creating an integrated water licensing system that is able to bring life or breathe life into what is considered to be a common good.
Any of our other panelists want to jump in on the issue of ownership of the water or the rights of use? Paul?
I would agree with Itzhak's observation that I think when there are strong legally recognized property interests, even if they're not ownership interests involved, it makes it much harder to do these types of regulations. And I think the experience that we have in California, but in much of the United States, is that when you want to do legislative governance reform about how you manage water, there's an anticipation that if the result of that is that you're going to take someone with some type of entitlement or permit and reduce their water, they are going to sue the government. They're going to sue the government for infringement of those property interests, and the value of what they're losing if they're being told to restrict or it's being reallocated to someone else could be tens or hundreds of millions of dollars of exposure for the government, which creates a disincentive to mess with existing systems, right? If you change anything, I'm going to come after you. So the problem is, to Tzak's point, is that it's one of those bells that's very hard to unring. Once you set up a system where there are certain, even if not ownership, where there are certain entitlements and rights, you can't throw it out in those countries without triggering claims that you've taken their right because they had a right that you took away. So, and maybe that's what he means by complicated, but it creates a real obstacle.
I think the word I would go for is expropriation, right? It's in effect you're expropriating that right away from them by regulating it. Yeah, I think you're muted, Paul.
I said, unlike the word usufructory, which rolls so easily off the tongue, right? It's just,
yeah. Mexico, China, any kind of perspectives on the ownership issues? I'm pretty sure I know the answer that in both countries, the government, the national government owns all water resources, right?
Yes. So in China's case, the ownership is vested in the country. So when a lot of like basic laws or regulations that are dealing with surface water already, or our assumption is surface water, then later on when the government want to have a new law regulating groundwater, sometimes just simply add something as it is applicable to groundwater, then there is no resistance from the society or from the government and from the people.
Thank you. Carmen, anything else from you or?
No, en México el agua es propiedad de la nación, ¿no? Entonces se asigna títulos o concesiones a usuarios y creo que pues ahora sí la jerarquía la tiene, como bien dice Paul, el gobierno para reglamentar. Aquí el problema no es que reglamente y quiera reducir algunas concesiones o regularizar. Aquí el problema es cuestión social y política que se da por la apropiación del uso de los usuarios. O sea, yo ya tengo años usándolo y entonces reducirlo implica condiciones económicas, sociales y políticas. Creo que ahí es el problema, ¿no? Básicamente.
Carmen, and let me just give a point here. The International Association for Water Law, we actually have a project right now ongoing where we are looking at different aspects of domestic groundwater regulations. And the issue we are now dealing with right now is actually ownership. And we have 10 jurisdictions that we're looking at, including Texas, where I live, where groundwater is owned privately by the landowners. And in conducting the research, I've actually found out that many Northern European countries have private ownership of groundwater. And I was surprised that we still have different variations in terms of how water is owned in different countries around the world. So look for the study from the International Association for Water Law, which will be coming out hopefully soon about ownership issues. But I wanted to move to another topic here. Shami Puri brings in, and I don't know if this is bringing in a political issue or just institutional governance issue, but there's a fundamental problem in many jurisdictions, he says, that the institutions that operate groundwater and surface water are actually operating separately in silos. The idea that one agency is responsible for groundwater and a completely different agency is responsible for surface water. And this deals in terms of regulating and licensing and so on. And so the idea of interconnected waters is at a fundamental level blocked by the fact that these two agencies are not interconnected. So I don't know what experiences you all have in your countries with whether it's a unitary approach, one agency, or different agencies that deal with surface water and groundwater. Who would like to begin? Carmen, do you want to start this time for Mexico?
Bueno, en México la realidad es que quien reglamenta ambas fases del ciclo agua superficial y agua subterránea es una sola institución. El problema es el enfoque que se le da para la cuantificación y asignación de títulos y concesiones de forma fragmentada o diferenciada de una agua superficial a una agua subterránea. Por ejemplo, en Chihuahua, que la mayor parte son aguas subterráneas, no se considera mucho la interconexión con el agua superficial porque no tenemos ríos perennes en la mayor parte del estado, ¿no? Entonces, esa interconexión como que no es visible o tangible. Entonces, creo que es un gran reto para visibilizar esto, que realmente, aunque parece ser que no existe, realmente es importante, ¿no? Es importante y que debe ser abordado de forma integradora.
How about Robyn, South Africa?
Just in keeping with the fact that in this country, groundwater and surface water are managed in an integrated fashion, the resource is defined as a connected hydrological cycle. The issue of silo management doesn't arise. There is no separation as between groundwater and surface water, institutionally speaking, that is. But while I was thinking now, where the problem does arise is on the ground, in fact. Catchment management agencies are established under the legislation to manage water on a regional level. And within the catchment management agencies, there may be, and this has been in the case of one that I have actually had reason to conduct some study in. The separation arises due to nothing but funding and human resources and the application to a particular project or the gathering of technical data or a project-based approach to finding solutions, water management solutions for a particular issue. So there lies in this jurisdiction, the real challenge to management and institutional, splitting up when it comes to groundwater and surface water.
Thank you, Robyn. Heping?
Yes, in China, we have a metaphor to tell you the water management. We're using 9 dragons managing water, which means about groundwater and surface water. They are managed by different institutions. So the precise picture to let you know about China is some aspects they are dealing with the same institution. Some part they are dealing by different institutions because there are so many institutions. They have certain authority to deal with water.
Complicated system. Paul, how about California?
I think I would just offer a tangible example of this silo problem. We have this state agency, the California State Water Board, that plays a role in issuing permits for surface water diversions and enforcing them. However, the State Water Board has no authority in general over groundwater pumping. So where you have a situation where groundwater pumping is reducing the flow in a stream, which means it's affecting all the surface water rights, it's not a question of having siloed agencies in California. We have no agencies. We have no agency, no government authority that is able to address groundwater pumping with those surface water impacts. So the only way that those issues get addressed is in the courts, where someone with a surface water right, sues someone whose groundwater pumping is affecting it. And so the developments that we've had have come through, Robyn mentioned the public trust, trying to use the public trust doctrine to deal with that situation. Or we've had other court cases. California Supreme Court in 1908 recognized that they were a common supply. I mean, this seems obvious. They're like, it's the same water. So we need to have a common supply rule, but having to resort to litigation as the only means of addressing it is a very terrible governance structure, and I don't recommend it.
Thank you, Paul. And we are, I think, are a little actually behind. So I'm going to bring it back to Imad for any kind of wrap up or concluding or summarization of the session.
Thank you, Gabriel. I just noticed that the topic of today was we're playing between delusion and reality, and we willingly or unwillingly participated in this delusion by having a panel only of lawyers instead of also inviting scientists to take part in this. So kudos to us to also keep going with this delusion. For the future, we have to be more careful to also involve scientists in the conversation. That's just the general observation I just had here. So we go back to the panel of today. There is this sense of optimism which can be noticed at the end from all the speakers, despite all the problems and the challenges that facing the topic of interconnected groundwater and surface water. As witnessed from, because once all the speakers were asked, provide at least one provision that you think could be important for dealing with this problem, each one of them was able to come up with a new idea, or at least more than one idea, or they had sort of a roadmap of how to move forward in this topic. So, although the challenges are a lot, it seems we know how to address them. So that's for me, that's the main lesson from today, that we have a way forward. It may be different when it comes to China, the US, Mexico, South Africa, or other countries, taking into consideration the contextual elements, also culture, religion, and other factors that we mentioned today, the difference between the laws, whether civil, common, or mixed systems. But at the end, it seems that each country or each expert in its own respective country is fighting its own fight to make sure that both groundwater and surface water are interconnected. And that's a great message to convey for the future, that we are actually more optimistic about the topic than anything else when comparing this to other problematics or dilemmas within the water field, where in many cases, collaboration is the exception and not the rule. So, but that was just the conversation taking place at a domestic level. And based on that, there are even more complications happening at the transboundary level. And for that, I will let Gabriel and Paul explain to us what will happen in the next webinar that will take place in a month. or Rosario?
Wants to take this, Paul, Rosario? I'm happy to do it, but
I'll take it. So the webinar that we had today, which was focused on delusions and reality at the domestic level, is part one of a two-part series. And on December 5th, we're going to be collectively the Permanent Forum on Binational Waters and International Association for Water Law will be hosting a webinar on these same delusions and realities, but in the transboundary context. So I'm going to be moderating that panel. Gabriel's going to be actually a presenter on it, talking about some of the emerging international law, water law framework around groundwater in general, but as it relates. I also saw that Gilbert Anaya was one of our participants today. He snuck in, didn't ask any questions, but we are going to be discussing how these issues of interconnected waters are being dealt with within the framework of the International Boundary Waters Commission between US and Mexico. We're also going to be looking at other examples from South America and from Southern Africa as well. So I think for those of you who found this topic interesting, if you want to sort of bump it up and think about how this all works when we're dealing with transboundary aquifers and transboundary basins and how that gets resolved, that's what we'll be addressing on December 5th. And I urge all of you to register and participate.
Thank you, Paul. Gabriel, any final words?
I just want to thank on behalf of the International Association for Water Law, and I know Rosario is going to jump in here in a minute on behalf of the Permanent Forum for Binational Waters, but I want to thank everybody for joining us today. I really want to thank the panelists for their insight and their contributions. This is really interesting. It certainly for me personally, but I'm hoping it's it for everybody else too. And lively discussion, and I really appreciate everybody's engagement here. Rosario, let me turn this over to you for last word.
The last word of wisdom. keep thinking. This is a complicated issue, and we want everything, right? We want to replicate nature in our legal systems. That's not an easy question to solve. It's not an easy process, but it is a process. So even though it's not the perfect one, even though we're not there yet, I think there are signs around the world where this recognition, it's clear, and we should move forward to that. Let's see if we do it on time based on the current challenges. Anyway, I just wanted to give thank you to our speakers, of course. We've been here for almost 2 hours, and we could be here forever talking about our delusions. I want to thank the audience, of course, the International Association for Water Law for joining us in this effort. And of course, to remind you of our next coffee break, which is going to be co-hosted as well. But now we're going to talk about all these issues at transboundary scale, which is even more complicated, which is even more delusional, and which is even more passionate. So anyway, thank you, everyone. Please be aware that we're going to post the live stream recordings both in English and Spanish on the website. And we will also try to wrap up a brief jointly with the forum and AIDA to get this in written as well and get the insights out there to share with other regions of the world. I see a comment here that we're missing the European perspective. I agree with that. It's hard to cover the whole world, guys. We're trying to do the best we can. So thank you, everyone, especially those in the East, California, for joining very early. And I'll see you in the next one. Thank you to our sponsors as well, as always, for the support of these events. Gracias a todos.
Thanks, everyone.
Gracias. Gracias, Carmen. Thank you, Paul, Heping, Imad, Gabriel, everyone, Robyn.
Thank you. Happy to be here.
Gracias.
I'm going to stop.